Having gone through the module, you're now familiar with some of the basic elements of what a contract is and some of the basic elements of how one pursues a contract action or lawsuit in a state or federal court. I'll share with you a couple examples of litigation, contract litigation with which I'm familiar and have run across over the years. I am a distant relative of Judge Marvin McLaughlin, who served in Stark County Court for some time, and one of his sons and I were talking briefly recently about a litigation that was between a local farmer and the company co-op that where he would put his product, store it for sale. And so the guys came in, and Judge McLaughlin ordered them to go into a room and see if they could negotiate it. And so the parties go into the room, and Judge McLaughlin starts to deal with another matter, and his son Brian happened to be in the courtroom that day. And the parties came out 30 seconds later, and Judge McLaughlin said, "You get right back in there." The parties then went back in for 5 minutes, and they came out with basically a negotiated settlement in which they split 50-50 right down the middle of the cost of the disputed amount of money, the dispute that they had with each other in their contract. So, as discussed in the module, the contracts that people can have are as unique and as diverse as the people themselves, and indeed the resolution of those matters can be as unique and diverse as the judge considering the thing. There are obviously rules for how contract actions, any kind of lawsuit, rules for how they are filed, how they proceed, the discovery process, the motion process, the motion practice. But at the end of the day, in terms of how the thing gets decided, it can be very much based on the parties and the judge's personality. I was familiar during my work at the Court of Appeals with a dispute between NIPSCO, a power company, and U.S. Steel, obviously a producer of steel. And the dispute had gone on for a long time, maybe 15 years maybe. And the parties ultimately entered into, depending on how you perceived it, 3 or 4 or 5 documents together, which constituted the agreement between the parties. The parties differed on whether 3 of the contracts or 5 of the contracts constituted the agreement. Regardless, the dispute was essentially about whether a price index applied after a number of years to a particular type of power. There are a couple different power products provided for in the contract. And so the disputed issue, which involved, my sense was that it probably involved lots of millions of dollars, was whether this price index, or essentially adjusting for how the cost of energy would vary over time, the parties said after a number of years, if there's so much change in the cost of sending electricity to you, U.S. Steel, we will index the price, and all of a sudden you're going to be paying some new price for the electricity. And so the dispute was whether that price index applied to just one of the types of energy products or both of the energy products addressed in the agreement. The matter originated with the Indiana Utility Regulatory Commission, which is an executive branch entity, and the IURC addresses any kind of dispute that involves a utility, public utility. So the IURC did not take any evidence other than the contracts themselves and concluded based on the 4 corners of the documents that made a conclusion about whether the price applied to this type of energy. When I say the four corners, it means that they didn't take any additional evidence about how much it made sense, no expert testimony about, well, it made sense for this thing to apply, or it made sense for energy to cost this much. The IURC literally just looked at the documents themselves and made a legal analysis, and indeed cited contract concepts for how they were interpreting the contracts. They were not exercising any discretion about facts that they had received in evidence other than the contracts, which were in fact not received during a trial. They were documents received attached to motions for summary judgment. Anyway, the judge for whom I work, Judge Mark Bailey on the Court of Appeals, wrote for a 3-judge panel in reversing the Indiana Utility Regulatory Commission. Judge Bailey applied basic contract law concepts, made no exercise of discretion about how much energy ought to cost, or didn't make any kind of judgment about any expert testimony. After all, there was none in the record. Judge Bailey did exactly what the IURC had done, which was to look at only the four corners of the documents, just the language contained therein, to make a contract analysis. So Judge Bailey, writing it for a 3-judge panel for the Court of Appeals, reversed the IURC. In a 4-to-1 decision, the Indiana Supreme Court basically went back with how the IURC had ruled and concluded that Judge Bailey had erred in his analysis. Now, I'll note that Justice Sullivan was the one dissenting justice on the Supreme Court who indicated that he thought the Court of Appeals got it absolutely right. Suffice it to say, it was a very interesting case. If you'd like to read more about it, the site for the Indiana Supreme Court decision is NIPSCO versus U.S. Steel, 907 Northeast 2nd 1012. That's Indiana Supreme Court 2009. Again, 907 Northeast 2nd 1012, 2009. And that overturned by a 4-to-1 decision the decision that my judge had issued. I'll make a note that actually applies to the next module when we'll discuss administrative law, but in its reasoning, the Indiana Supreme Court gave great deference to the Indiana Utility Regulatory Commission, which indeed has a membership that is supposed to have expertise in utility law, and indeed the people on there do have expertise in utility law. That's the entire idea behind administrative law, is to put experts in a particular area of the law into decision-making capacity in those areas. But the Indiana Supreme Court gave deference to the IURC decision, even though the IURC had simply applied basic contract law concepts in its analysis. It had not exercised any discretion in fact-finding. It had not even taken expert testimony. The only evidence in was, again, the exhibits, the documents, the contracts that were attached to the parties' respective motions for summary judgment. Point being, in administrative law, the appellate courts will give great deference to administrative bodies, even where they are acting entirely on contract principles that are known just as well to the Indiana Court of Appeals, if not better, than to the respective board or commission of the executive branch. So suffice it to say, the Indiana Supreme Court and other courts give great deference to administrative bodies. It was a fascinating dispute, and those are a couple of examples. One quite modest and one pretty large in terms of the amount of money at stake. But when it's your money, it's always taken pretty seriously.